Good morning. May it please the court, my name is Ethan Tramontanis, representing the appellant Seattle police officers. With me today at council table is my co-counsel Lisa Battaglia. I'd like to reserve 3 minutes for rebuttal. The appellant officers are challenging the City of Seattle's use of force policy, which restricts officer safety and disregards the practical, everyday dangers and difficulties of policing. The policy violates the officers' fundamental constitutional rights to self-defense under the 2nd and 14th Amendments. The genesis of the case was an investigation by the Department of Justice into the SPD in 2011. Using a sample of use of force reports, the DOJ found that when they used force, SPD patrol officers did so in an unconstitutional manner nearly 20% of the time. This statistic has since been discredited. Nonetheless, the city consented to a settlement agreement with Department of Justice and agreed to revise their use of force policy. The revised use of force policy went into effect January 1st, 2014. In the ways identified in the first amended complaint, the policy is overly complicated, contradictory, and dangerously restrictive. It requires officers to behave in a delayed, contrived, and specific way to situations that are unpredictable, fluid, and fast-moving. It predicts the officers from using force unless they engage in multiple steps of analysis, and then requires them to continue to perform analyses and checklists while deciding what force to use and the extent of that force. Therefore, it restricts
We've kind of got this in your brief, what you're telling us now. The issues you've really got to focus in on, or is it a violation of any of these amendments, regardless of what the policy is? And we've read it, and we know what you've said in your briefs about that. So why don't you focus in on these amendments? What amendment are you going to focus in on first, and why is it a violation there? I mean, if I were to take control of your argument and you don't have much of it, I'd start on equal protection because I don't think there's anything there. But, and then I'd let you get back to Second Amendment, but you really got to make your real case under the Second Amendment. So maybe you ought to start there. Why is it that it's protected under the Second Amendment?
The district court erred when it held the Second Amendment doesn't protect against restrictions on the right to use force in self-defense. And this court used the two-step analyses, the two-step inquiry for Second Amendment claims, asking whether the challenge policy burdens conduct protected by the Second Amendment.
First of all, Chauvin. Chauvin says the first step is whether the policy regulates the use of force in self-defense, not burdens it, regulates it. And then if it regulates it, depending to what extent it regulates it, then you either apply intermediate scrutiny or strict scrutiny. So why don't you address those issues?
This policy clearly regulates the officer's use of force.
It does.
It does.
Now, how closely does it regulate the core Second Amendment right, which is stated in Heller and McDonald, to use self-defense to defend home and hearth?
A fair reading of Heller doesn't restrict the use of self-defense to the house.
I quite agree with you, and we said that in Chauvin. I was on the panel. The right is one of self-defense.
Right.
Now tell me, in what particulars is a policeman inhibited from using his firearm under the right of self-defense by the UF, by this policy?
The policy absolutely restricts officers from using any force, including the firearm, until they go through this de-escalation scheme. And to go through the de-escalation scheme, you have to look at why the subject's not responding, and you have to consider one of 7 reasons.
Well, isn't a de-escalation scheme simply a very thoughtful way of piling up the elements of reasonableness as to the use of the gun?
No, it's an absolute restriction before they can even get to the use of a gun. And it is...
You read this policy as telling policemen you must abandon your reason and follow a policy which is unreasonable?
That's right. That's what we're saying. Now, there is a
That's what you're
reasonableness.
saying, okay.
There is a reasonableness standard, but that comes into play after the de-escalation happens. And de-escalation is defined as the mitigation of an immediate threat. And when police are facing immediate threats, it's unsafe for them to go through this de-escalation. But once they do, then you get to the standard of reasonable, necessary, and proportional.
Is it your point that a policeman, before he decides to use his firearm to protect himself, must go through the mental exercise of the de-escalation process, and that in itself imperils his life?
Absolutely.
Now, do we have any examples of how that has worked in practice?
Well, this was a 12B6 decision by the district court.
But you must allege, under Iqbal and Twombly, facts, not contentions, facts,
right.
which plausibly say that police officers are paralyzed or frozen in the use of reasonableness as to the use of the firearm while they go through the de-escalation process. Do you do that in your pleadings?
We do in ER 31 to 32 and ER 35 to 37.
Counsel, in your view, if the court gets to the second step, is remand required?
It is.
And why is that?
Because the district court didn't get to the second step. They hit the first step and said that the officers while they have a right to bear arms, they don't have a right to use the arms in any particular way. This was error. Because the core component of the Second Amendment, as Judge Baez said, is for self-defense. So
Let me ask you a question. Before we get to the second step, let's go to the first step. Seems to me under the first step, whether the challenge law burdens conduct protected by the Second Amendment has two different prongs, right? First prong would be that it was based on a historical understanding of the scope, which was outlined in Heller generally. But the second prong is whether the challenge law falls within a well-defined and narrowly limited category of prohibitions.
right.
Who has the burden on that prong? Who has the burden of proof on that prong?
The city would, because it's an exception to.
Why is it the city would?
Because it's an exception to the rule. If we show that it impacts the core component of the Second Amendment, which we have, then the city would have to show that that it's a historical
Well, I
exception.
ask whether the challenge law burdens conduct protected by the Second Amendment. That's what Fiat versus Sunnyvale would have me ask. If I'm asking that, and then Jackson says I have to ask whether it was burden conduct protected based on the historical understanding, and then the second part is whether the challenge law falls within the well-defined and narrowly limited category of prohibitions, why is that not your burden? You're the one who has to show that somehow this challenges burden conduct by the Second Amendment.
Okay.
Why is it not your burden? Because to be fair, there's not much in this record about the prohibitions that have historically been unprotected. And frankly, that's where the district court came out with her understanding here. She said there's nothing here that says this is a prohibition. There's nothing here that suggests that it is, and so therefore I end here. So I'm putting it right to you, and I'm going to say the same to the government. I mean, there's no question in Judge Baez's case of Chauvin, which is a criminal case, he put the burden on the government. But this is not a criminal case. This is a civil case. And you're the one challenging the law. And frankly, I don't find anything in here that suggests that there was, in fact, a prohibition that had been historically unprotected.
If it's my burden, Your Honor, then going off the language of Heller, the longstanding prohibitions that were listed were prohibitions on the possession of firearms by felons.
You're talking about the understanding of the scope. I'm going on bigger than that. I'm understanding now the challenge conduct has to go between something that is a category of prohibitions that have historically been unprotected. And in general, in these cases, I having sat on a few, I have all kinds of law review articles about this. This isn't the record that's in front of us. This is a record of all kinds of law review articles which would get me to this part. It's not in this record.
Because we're relying on the language of Heller and McDonald, which went through the history of the Second Amendment.
You don't get through this. You don't get even to you don't even get to the second prong. That's what the district court did. That was its analysis.
I believe the district court said that the officers didn't have the ability to, or didn't have a constitutionally protected interest in using a weapon in any particular way.
And the reason why is because she couldn't find any prohibition that was historically protected here. In fact, she found it wasn't there.
Well, the officers aren't asking for a policy for no policy.
She said, you're now in government work. You're now using these weapons only because the government provides them to you, and when the government provides them to you, the government ought to give you a chance or some, if you will, direction on what to do with them. And she said, I can't find anything that's a prohibition of this in history. And there's nothing in the record to suggest it.
The officers aren't arguing that there can be no restrictions on the policy. They're arguing for a reasonableness standard. That the question is whether the officers' actions are objectively reasonable in light of the facts and circumstances confronting them. And because, yes, the city gives the police officers guns, but they're required to carry those guns, and they're required to go into dangerous situations and face them. And they have to have the ability to defend themselves because they're duty-bound and mission-bound to walk into danger.
So if I get you through the first prong, and now I go to the second prong, why is this case require any more than intermediate scrutiny?
Because your analysis here, if you're going to apply the tiers of scrutiny and not just go off of the text, history, and tradition of the Second Amendment, the question is how close the challenge policy comes to the core of the Second Amendment right. That's the first step. And self-defense is the core of the Second Amendment right. And then the next step is the severity of the policy's burden on that right. And then it's an absolute restriction of using force until you go through these steps.
As I understand you, sir, the only difference between the right of the officer to use his firearm and the right of a citizen to use his firearm in self-defense is that the officer is burdened by having to go through the mental checklist, which will freeze him to a point where he can't reasonably defend himself. Is that correct?
That's right.
Then it's not an absolute restriction then, correct?
Well, it's a restriction until they go through that checklist. And then once they finish the checklist, then they have additional restrictions about unreasonableness, necessary, and proportionality. So it doesn't end. And Your Honor's right. It is the frozen, what am I supposed to do here, that increases the danger to the police officers and restricts their constitutional ability to defend themselves.
Well, if it really regulates conduct close to the core of the Second Amendment, then how do I distinguish these cases like Enquist, Cafeteria and Restaurant Workers Union versus McElroy, which suggest it isn't quite that close when you're a proprietor and you're managing the internal operation of your police officers?
I'm sorry, Your Honor, I'm not familiar with that case.
Okay. Sorry.
You want to save a minute for rebuttal?
I do, thanks.
May it please the court. I'm Greg Narver, representing the city of Seattle. The district court's dismissal of the amended complaint should be affirmed by this court in every respect. And while I'm happy to answer questions about any of the claims in the case, I plan to focus today on the Second Amendment and, time permitting, the substantive due process claim under the 14th Amendment.
Don't you see, Mr. Narver, that this regulation in some manner does regulate the right to use a firearm?
It regulates when officers can use a firearm, but I'm going to go further and say it doesn't regulate any right protected under the Second Amendment. These are not Second Amendment concerns.
Under Chauvin, we said that if it regulates the right to use a firearm in self-defense, then that establishes the burden under the first step. Then the question is the measurement of how close the burden comes to the core right of self-defense, and to what extent does it burden it.
I agree that that's what Chauvin said.
So therefore, I think you'd be better off by directing your remarks to whether the second step is fulfilled, because it does seem like under Chauvin, the first step exists.
Well, Your Honor, with all due respect, I'm going to take a stab at telling you why the first step does not exist.
Okay.
And this has to do with part of the holding of the district court's opinion, and I believe it's what Judge Smith was alluding to a second ago. There's a threshold issue of whether the rules that a police department sets for the government-owned weapons that it issues to its officers to use on duty, and then the rules it sets when you can use these weapons and how, whether the Second Amendment has any role at all in assessing the validity of those rules. Now, the appellants take it as a given that it does apply, but the district court called this a novel theory, and I think that was absolutely correct. I think you can start with the analysis in Heller, which catalogs, as you know, hundreds of years of history beginning in England. The common thread throughout that historical inquiry is that the right that was eventually codified was the right of the people to bear arms against infringement by first the crown. There's talk of James II, Charles II, and George III, all the efforts they tried to disarm both England and the American colonies. And that's what was being codified as an individual right against infringement by the government, but nothing in any case law or the historical sources suggests that the Second Amendment applies to the arms that are possessed by the government itself and are used in the course of government action. I think the text of the amendment, I'm sorry, Judge Smith, you look like you had a question.
Well, the reason I was going to ask, who carries the burden on this issue?
The plaintiffs have brought the claim. They're the ones who have to show, I believe under Heller and this two-part analysis, that the right they're asserting is one that the first part of the test. Does it burden?
However, I read Chauvin to suggest the government has the burden.
I think that either way, this is an issue of law about the scope of the Second Amendment. I frankly don't think it matters who has the burden. I'm happy to try and persuade you.
The reason I ask you that is because I've seen these cases before, and we get to this point, and I'm looking at all these law review articles and all this stuff that has to do with whether in history this category of prohibition has ever been protected or not. And I'm trying to find it. In this case, I don't have that.
I don't have it either. It has never been protected. The idea that the weapons possessed by government actors, police officers, members of the military, are subject to Second Amendment restrictions.
But what you're saying is to a policeman, A, you can't carry anything but a service revolver, and it's our revolver. B, you can't use it.
No, I'm saying that an officer...
I mean, when you say that it's only the government restricting its own arms, that assumes that the government is restricting the individual citizen from using a gun to protect himself. True?
I might have lost the train of your question.
Well,
I'm sorry.
Once you tell the officer he can't have anything but a service firearm...
At home or as an on-duty police officer?
On his job.
Okay.
All right? Mm-hmm. And then you say, we're regulating that. That tells him that as a citizen, he can't use his arm.
No, it tells him as a police officer, he's subject to the rules. Now, for the most part, by the way, recognize that on-duty police officers have far more expansive rights with respect to weaponry than the general public. When a police officer's at home, the same rules apply to any other member of the general public. That's the Heller case, where the plaintiff was a police officer.
I'm not getting across to you. Go ahead with your argument.
I'm sorry if I haven't addressed your question.
No, go ahead with your argument. I'm not getting across to you.
Okay. In this state, for example, there are weapons that the general public can't possess, like fully automatic rifles. Police officers can't by law, so can members of the military. There are places the general public can't bring weaponry, like courtrooms, schools. Police officers can. Police officers are obviously authorized to use force in the exercise of police powers, like effecting an arrest. That's not a power the general public has. But no case, and none of the historical records, and I know council's read them, and I know the court has, and I have, there is no suggestion that the weapons possessed by the king's forces or anyone else is a Second Amendment concern. This is consistent with the construct of the Bill of Rights. Unlike other parts of the Constitution where there are explicit grants of authority to the government, this is about the rights that are possessed by the general public against interference by the government.
And supposing I don't agree with you, then what do you do with the second part of the test?
Well, we think this is not a strict scrutiny case. This is an intermediate scrutiny test.
I mean, I'm moving you along because your argument is dwindling. And you've got, I mean, you had someone you started, you're down to 851. So I've heard what you're saying as to the first prong. What about the second prong?
If we get to the second prong, it's an intermediate scrutiny test. If the challenged law doesn't implicate a core Second Amendment right or doesn't place a substantial burden on it, it's intermediate scrutiny. Here, the reason for the de-escalation procedures was to address specific concerns raised by the Department of Justice in its findings, that there were uses of force, often against people in mental crisis, where some slowing down of the process might have avoided the use of force.
Excuse me, Counsel, how would you define the core Second Amendment right?
Well, Heller says a lot about what those are, but it's essentially what I've said. It's the right of an individual clearly to defend hearth and home, where Heller is. I know there's been some question about how far outside the home that
Right of a
that goes.
law-abiding.
Exactly, but where we're talking about police officers, I'm saying, first of all, of course, the answer to question number one is no. If somehow regulation of officers is incorporated in it, I don't see that as a core constitutional right. It's the right of the people who were being disarmed by the king in England or the colonists in America.
So in your view, how close does it come, does the right of a police officer to use a firearm in self-defense come to in your view, the core Second Amendment right?
It's not a Second Amendment concern at all. If there are constitutional limitations on what a police department can say, essentially taking the use of force off the table altogether. Now, that's not this policy, of course. But the one constitutional limitation that's in this complaint that might apply is a substantive due process one, where there is an established body of case law about executive government action that places government employees at unreasonable risk. It's an incredibly high burden to meet. And we argue that the amended complaint here, which is based on 3-year-old allegations before the policy had really even taken effect, doesn't come close to meeting the standard. But if there are concerns about you're freezing our ability to use force, substantive due process is the right way to talk about, is the right area to focus on. The Second Amendment, these are not Second Amendment concerns. A lot of, not every carrying of arm in this country derives from the Second Amendment. And the arming of police departments like the military, those are not Second Amendment concerns. That is about the individual protecting from infringement by the government. If we are going to talk about, is this government action that has put its employees too much at risk, then we're under substantive due process. And there are two ways they can make that case. One is the shocks the conscience standard. I don't think we're anywhere near that with this policy that, hyperbole aside, this doesn't disarm the police. They have the right to carry arms. They have the right to use those arms. There are some de-escalation steps that have been called into question. The other thing I want to stress, and this has to do with the 2 requests for judicial notice we made, is that we know what happened under the policy. We have another federal court, Judge Robart's court, with 3 years of actual data in front of it showing how this has played out. Now, we have not asked the court to take judicial notice of the data that's in those filings, simply to note that there is another court where this has all played out. And so rather than appear there's been no motion to intervene or to appear as an amicus by the appellants. They go on a 3-year-old record at the outset of the policy, ask this court to accept it all as true, and then essentially make new law. Take the Second Amendment to a place it's never gone, and the 14th as well, declaring a new fundamental right. We don't think anything there comes close to meeting that standard.
My good colleague, Judge Hayes, asked, should we remand this case since the district court only considered the first prong?
No, I don't think there's any need for a remand. This can be decided on all issues as a matter of law by this court. The full policy is in the record. The court can see, as the district court did, that nothing about adding this de-escalation step shocks the conscience. And again, we assert that nothing pled in the complaint about a police department policy. It's a novel theory, as the district court said. It doesn't invoke any core Second Amendment right. I also would point out that the substantive due process cases we've cited, Collins, County of Sacramento from the Supreme Court, Slaughter from the Fourth Circuit, Lemire from this circuit, are all decided on motions. The appellants chose to file this at the outset of the case. It's essentially a facial challenge at that point to the policy because a record hasn't been developed to show here are instances in which de-escalation has caused harm. That's the record they took up on appeal. Nothing prohibits them. They can be in this court making this constitutional challenge and also go to Judge Roberta and say, based on 3 years of experience, we were right 3 years ago. Here's what has actually happened. Judge Roberta has in front of him right now a new set of proposed modifications to the use of force policy. They don't touch on de-escalation, granted, but wouldn't this be an opportunity for a party with genuine concerns about what's happened in the last 3 years to appear in this court, in his court, and say that? It doesn't preclude them from making a facial challenge here, but rather than accept essentially speculative allegations as true, they ought to be in front of the court where we know what has actually happened over the last 3 years. They've sat those proceedings out altogether and are asking you to create new law instead. So I don't believe a remand is appropriate. If they want to file a new as-applied challenge, I presume this court's opinion could grant that right, that the challenge they made at the outset, that nothing on its face about this policy violates the Constitution, we think that should be affirmed. If there are real concerns about the way this has played out over the last 3 years, it ought to be on a full record or in front of Judge Roberta. Seattle, as you know, is one of a number of cities around the country where police reform is playing out under the oversight of a federal judge, which is what we have here. Baltimore, Cleveland, Ferguson are a few of the other examples. In our consent decree, the use of force policy is the absolute centerpiece of it. It was at the heart of why the Department of Justice came here. It is critically important that we get that policy right. And if the officers can show something about it that hasn't been working, they ought to be participating in those proceedings. But that's not what they're doing. They're asking you to come here and create a new fundamental constitutional right under the 14th Amendment and apply the Second Amendment to arms possessed by the government, which has never been done before. So we are asking you to affirm the district court's order on the merits. This court can do that knowing that there is an alternate forum available to the appellants to express concerns about the policy, whether it's in the form of a constitutional challenge or just a practical one. Here's why those de-escalation things aren't working for us. They can take those concerns there. This court, however, should dismiss on the merits. Happy to answer any additional questions. Thank you.
Your Honor, there's no alternate forum available to these police officers. That's why they brought this case. And the reason why we're talking about the allegations in the pleading, because this was on appeal of a 12B6 dismissal. The officers didn't get to present evidence of how this policy impacts them. On the substantive due process, it was error for the district court to use the shocks the conscience standard. The Sacramento versus Lewis case says you use the shocks the conscience standard when an action is executive as opposed to legislative. In other words, it depends on whether the challenge action is aimed at a specific act of a government officer at issue, and that's not this case. This is a Manel challenge on the policy.
Don't you believe that this is really a new ground? If we take this to substantive due process, don't you believe that we're really breaking new ground in this field?
Yes.
And so then how do I rectify the case of Collins versus the city of Harker Heights, Texas, which is the United States Supreme Court telling me, don't do it?
Let's say that a police officer doesn't have a right to a safe workplace against other police officers. I believe that was one where a police officer was shot in the line of duty. This is different. This is the government imposing a policy.
I'm frankly having a hard time understanding why this is so different. As I read Collins, and you're now talking to me about the facts, and you're saying this is worse than that? And they said in Collins, don't get involved, that's not your area. This is uncharted area, scarce, open-ended. The doctrine of judicial restraint says don't go there.
But we have Heller that says self-defense is a fundamental, long-standing right. And if there's a fundamental right, then there's a substantive due process violation. I want to talk about the policy one last time, because we've been focusing on de-escalation, and this isn't just a matter of de-escalation. Once you get through the de-escalation, the use of force needs to be reasonable, which includes the consideration of 13 factors, and then necessary and proportional. And it defines necessary as no reasonably effective alternatives are available. And this court, in its Scott v. Hendrick case, said that that's an impossible standard. And so when you're asking, are there historical recognitions of an officer's right to use force, perhaps that would be in the Fourth Amendment case law. This court said requiring officers to find and choose the least intrusive alternative would require them to exercise superhuman judgment. In the heat of the battle, with lives potentially in the balance, an officer would not be able to rely on training and common sense to decide what would best accomplish his mission. Instead, he would need to ascertain the least intrusive alternative, an inherently subjective determination, and choose that option and that option only. Imposing such a requirement would inevitably induce tentativeness by officers and thus deter police from protecting the public and themselves. And that's what this case is about. The Second Amendment right to protect herself exists and applies to the police officers. And if the court finds that, then we get sent back to the district court to develop a record on how it impacts the officer's core Second Amendment right.
Thank you very much.
Thank you.